mengumumkan keberangkatan Duli Yang Maha Mulia Pemangku Raja Perak Darul Rizwan dan Duli Yang Teramat Mulia Raja Puan Besar Perak Darul Rizwan diiringi oleh The Right Honourable Lord Sumption and Lady Sumption, Vice Chancellor dan Menteri Besar of Perak. Ampun Tuanku, Patik mohon perkenan Duli Yang Maha Mulia Tuanku untuk Patik meneruskan acara majlis ini dalam bahasa Inggeris. Your Royal Highness Raja Nazrin Shah, Regent of Perak Darul Rizwan. Your Royal Highness Tuanku Zara Salim Raja Puan Besar Perak Darul Rizwan. The Right Honourable Lord Sumption and Lady Sumption. Your Highnesses, the Honourable Menteri Besar of Perak, the Right Honourable President of the Court of Appeal, the Right Honourable Chief Judge of Malaya, the Right Honourable Chief Judge of Sabah and Sarawak, Your Excellencies, my Lords, distinguished guests, ladies and gentlemen. My name is Ben Ibrahim. On behalf of the trustees of the Sultan Azlan Shah Foundation and the University of Malaya, I have been given both the privilege and the honor to welcome each and every one of you to the 27th Sultan Azlan Shah lecture this evening. Ladies and gentlemen, pray silence for the royal address of His Royal Highness, the Regent of Perak. Ampun Tuanku.
The Right Honourable Lord Sumption and Lady Sumption, His Royal Highness Sultan Azlan Shah was particularly looking forward to this lecture, but on the advice of his personal physicians, His Royal Highness is unable to grace us with his presence this evening. His Royal Highness Sultan Azlan Shah and Her Royal Highness Tuanku Bainun have asked me to convey their personal greetings to you both and to extend their deep regrets in not being able to grace this evening's event. My wife and I wish you both a very warm welcome to Malaysia. On behalf of the Sultan Azlan Shah Foundation and the University of Malaya, I thank you, Lord Sumption, for the honor you bestow on us by being the speaker for this evening's lecture. Ladies and gentlemen, the Right Honourable Lord Sumption needs very little introduction. Your overwhelming presence here this evening is clear recognition of His eminence. Lord Sumption is one of the most outstanding jurists in the United Kingdom, if not in the Commonwealth. His elevation directly from the English bar to the highest court in the United Kingdom, the Supreme Court, the first barrister in over 65 years to do so, is a clear testimony of his brilliance. During the relatively short period during which Lord Sumption has sat on the Supreme Court, he has already made a significant mark by delivering some of the leading judgments of the court. Only recently, in an important decision of the Supreme Court, Lord Sumption held that school authorities could not delegate their duty of care towards school children to a third party so as to absolve it from an action in negligence brought against the school. In that case, it was held that the school was still liable in negligence when a student suffered serious brain injuries during a swimming lesson in the school swimming pool, even though the school did not conduct the lessons itself. In another case, decided earlier this year, Lord Sumption elucidated with clarity the century-old principle of company law, the doctrine of piercing or lifting of the corporate veil, and how it may intersect with a matrimonial case. In that case, 7 properties, 5 of which were in London, were held by 2 offshore companies and not in the name of the husband. The question before the Supreme Court was whether the court had power to order the transfer of these 7 properties to the wife, given that they legally belong not to the husband, but to his companies. It was held that as the husband and not the 2 companies had provided the funds to purchase the properties, and as he had control over the 2 companies, the properties were held on trust for her husband and therefore form part of the matrimonial assets which the wife was entitled to. This decision has been hailed as a landmark decision in both company law and family law. One fact that many of you may not be aware of is that Lord Sumption, even before studying law, read history at Magdalen College, Oxford, where he obtained a first. Subsequently, as a fellow of Magdalen, he taught history for 5 years. It may come as a surprise to some of you that Lord Sumption is quoted to have said, "I don't love law, but I enjoy practicing it. I do love history." His first book on pilgrimage in the Middle Ages was published in 1974, followed by the Albigensian Crusade in 1978. Since the late 1990s, he has been engaged on a vast narrative history of the 100 Years' War. 3 volumes have been published to critical acclaim. I understand that there will be another 2, the 4th being scheduled to appear in 2015 to coincide with the 600th anniversary of the English victory at Agincourt. His work on the 100 Years' War has also been aptly described as a magisterial account and one of the great historical works of our time. Only after his stint as an academician did Lord Sumption pursue a career in law. To quote him, "Eventually, law seemed to offer the best opportunity for an intellectually stimulating occupation with the opportunity to make a reasonable living." Today, besides being a brilliant jurist and a well-regarded historian, Lord Sumption is a governor of the Royal Academy of Music. He plays the piano and has a keen interest in the opera. He is truly an amazing and inspirational figure to all of us who have not pursued a legal career as yet and are harboring an ambition to do so. Ladies and gentlemen, it now gives me great pleasure to invite the Right Honourable Lord Sumption to deliver the 27th Sultan Azlan Shah Law Lecture. The Right Honourable Lord Sumption.
Your Royal Highness, ladies and gentlemen, It is a great honour, as well as a personal pleasure, for me to be giving the Sultan Azlan Shah lecture this evening. This is the 27th lecture in this distinguished series, and I am conscious that I am following in the footsteps of some of the outstanding jurists of the common law world in our time. I'm also conscious, as I suspect all of us in this room are, that I am doing so in the absence of His Royal Highness Sultan Azlan Shah, for whom these lectures have been a source of justifiable pride for many years. I am sure that I reflect the feelings of all of us in wishing him a swift return to good health. On a more personal note, Teresa and I are truly grateful for the extraordinarily generous hospitality which we have received from their Royal Highnesses during our brief stay in this fascinating country. The title of my lecture is not, I am afraid, calculated to tell you very much about its contents. That is in part inspired by a very well-known lecture published in 1978 called The Forms and Limits of Adjudication by Lon Fuller, the distinguished legal philosopher who held the chair of law at Harvard University for many years. Professor Fuller took as his starting point the fact that the system of adjudication by courts of law was what he called a form of social ordering. It was part of the complex mechanism by which the relations between people are governed and regulated. It operates side by side with other means of social control, such as legislation, administrative action, professional self-regulation, and more or less powerful social or cultural conventions. The question which Fuller asked himself was this: what kinds of social tasks can properly be assigned to judges and courts, as opposed to these other agencies of social control? It is a much debated question, and there are two features of our legal culture that make it a particularly important and difficult question. The first is that in the common law world, there are unquestionably important areas in which judges necessarily make law. In a precedent-based system, they lay down general statements of principle, which then stand as authority in future cases. Judges do not simply discover legal principles concealed in the luxuriant undergrowth of ancient principle or scattered about forgotten decisions, as the great 18th century jurist William Blackstone supposed, and as generations of common lawyers have subsequently pretended. They make law within broad limits determined by statute and by legal policy. In recent years, appellate courts in the United Kingdom have been increasingly open about this. In 2005, in Re Spectrum Plus Limited, Lord Nichols of Birkenhead put the point in this way. Judges, he said, have a legitimate law-making function. It is a function that they have long exercised. In common law countries, much of the basic law is still the common law. The common law is judge-made law. For centuries, judges have been charged with the responsibility of keeping this law abreast of current social conditions and expectations. Just as common law judges make law, so also they unmake it. They overrule past decisions, even those of the highest appellate courts. The declaratory theory of law holds that in that case, the earlier decision must always have been wrong. It just took the courts a long time to realize the fact. As Lord Reid put it in West Midland Baptist Association and Birmingham Corporation in 1970, we cannot say that the law was one thing yesterday, but is to be something different tomorrow. If we decide that the existing rule is wrong, then we must decide that it has always been wrong. Now, this is now overtly recognized as the fiction that it always has been. The courts of the United States, of India, of Ireland, and of the European Union have all asserted the right, in certain categories of case, to overrule a decision only with prospective effect, a function previously regarded as the special privilege of the legislature. In the Spectrum Plus case, the House of Lords held that in a suitable case, the English courts could do so too. So judges can now not only say that the law was one thing yesterday and another thing tomorrow, they can actually admit that that is what they are doing. It is a very significant power. It is not a power that would be recognized in all legal cultures. Article 5 of the French Civil Code, which has been part of the code from its inception at the beginning of the 19th century, provides judges are not permitted to adjudicate on cases before them by way of statement of general principle or statutory construction. What that means is that judges may only formulate principles applicable to the particular facts before them. They may not purport to lay down general rules which would apply in any other cases. That would be classified as an essentially legislative function. In keeping with that principle, there is, with very little exception, no doctrine of precedent in French law. Now, that is one reason why the social and political implications of judicial decisions in France and in other civil law countries are usually more limited than they can sometimes be in common law jurisdictions. There is a second reason why we need to think seriously about the proper role of judges in the ordering of society. We live in an age of unbounded confidence in the value and efficacy of law as an engine of social and moral improvement. The spread of parliamentary democracy through most of the world has invariably been followed by rising public expectations of the state, of which, of course, the courts are a part. The state has become the provider of basic standards of public amenity, the guarantor of minimum levels of security, and increasingly the regulator of economic activity and the protector against misfortunes of every kind. The public expects nothing less. Yet protection at this level calls for a general scheme of rights and a more intrusive role for law. In Europe, we regulate almost every aspect of employment practice and commercial life, at any rate so far as it impinges upon consumers. We design codes of safety regulation designed to eliminate risk in all its infinite varieties. New criminal offences appear like mushrooms after every rainstorm. It has been estimated that in the decade between 1997 and 2007, more than 3,000 new criminal or regulatory offences were added to the statute book of the United Kingdom. Turning from statute to common law, a wide range of acts which a century ago would have been regarded as casual misfortunes or as being governed only by principles of courtesy are now actionable torts. This expansion of the empire of law has not been gratuitous. It is a response to a real problem. At its most fundamental level, the problem is that the technical and intellectual capacities of mankind have grown a great deal faster than its moral sensibilities or its cooperative instincts. At the same time, other constraints on the autonomy and self-interest of men, such as religious and social convention, have lost a great deal of their former force, at any rate in the West. The role of social and religious sentiment, which was once so critical in the life of our societies, has now largely been taken over by law. So, when Lord Nichols spoke in Spectrum Plus of the judiciary's duty to keep the law abreast of current social conditions and expectations, he was making a wider claim for the policy role of judges than perhaps he realized. Popular expectations of law are today, by historical standards, exceptionally high. Now, if judges in a common law system can make law, then where does judicial lawmaking end and politics begin? In theory, English law has a coherent answer to this question. It was the answer given by Lord Diplock in his speech in the House of Lords in the Crown and Inland Revenue Commissioners' ex parte National Federation of Self-Employed and Small Businesses in 1982. Parliament is sovereign and has the sole prerogative of legislating. Ministers are answerable to the courts for the lawfulness of their acts, but they are accountable exclusively to Parliament for the efficiency with which they carry out those acts, and of those things Parliament is to be the sole judge. Now, this statement is neat, it is elegant, and it is perfectly useless because it begs all of the difficult questions. What is a question of law? What's a question of policy? The Diplock test will yield a different answer depending on how you define the issue. Let me illustrate this point with an example, not particularly important in itself, but nevertheless, I think, revealing. In England, the administration and jurisdiction of the higher courts is governed by the Senior Courts Act 1981. Section 130 of that Act, which remained in force until 2003, is not normally regarded as a great engine of social policy. It empowered the Lord Chancellor to fix the level of court fees. In 1997, the Lord Chancellor introduced new regulations. Their effect was to increase the court fees, while at the same time leaving out provisions in previous regulations which had exempted people on income support. The object was to reduce the net cost to the state of funding the court system, but the effect, of course, was necessarily to make access to the courts more expensive for the poorest section of society. Mr. Whiteham was a man on income support who wanted to bring an action for libel but couldn't afford the court fee. So he applied for judicial review of the new regulations. This case is reported under the title The Crown against the Lord Chancellor ex parte Whiteham. Now, there are at least 3 different approaches that one could take to Mr. Whiteham's problem. The first would be to say that a service like the administration of justice should be viewed in exactly the same way as any other service provided by the state. It is simply one of a number of competing claims on a limited pot of money. All public services have an opportunity cost. The money that is spent on one of them is not available to be spent on another, which might be equally beneficial. Who is to say whether it is more important that the poor should have affordable access to the courts, or that they should have affordable access to hospitals, schools, or any other publicly provided services of the state? Now, that is precisely the kind of policy decision which, on any orthodox view of English public law, is not a matter for judges. It is an inescapably political question. But there is a second approach that one might take. One might say that affordable access to justice was so fundamental a right that the state was under an absolute duty to provide it at whatever cost. From that, it would follow that access to justice trumped all other calls on the state's budget. Now, put like that, the question ceases to be a political question and becomes a legal one. A third approach is to recognize the absolute character of the duty to provide affordable access to the courts for the poor, but to do it in some other way. For example, one might make legal aid available on a more generous basis, or one might increase income support payments so that the higher court fees become affordable. This approach, of course, raises yet further questions. The practical effect of providing legal aid is to increase the resources available to citizens, but provided that they spend it on litigation. Yet is litigation such a valuable part of our social culture that we ought to privilege it in this way. Suppose that Mr. Whiteham's income support payments had been increased by enough to enable him to pay the court fee. He might have preferred to spend the money on a holiday. Is this a course that ought to be denied to him? Now, these are not straightforward questions, but more important than their inherent difficulty is the fact that they are not legal questions. We are back in the realm of politics. Mr. Whiteham's case came before a divisional court of the Queen's Bench Division, which quashed the regulations. Mr. Justice Laws, one of the most thoughtful constitutional lawyers to have sat on the English bench in recent times, delivered the leading judgment. He considered that access to justice at an affordable price was not just another government service, it was a constitutional right, which could only be restricted with specific statutory authority. Since Britain does not have a written constitution, Mr. Justice Laws was exercising a purely judicial authority when he declared this constitutional right to exist. What he did not do was to consider the implications of the question before him for the distribution of the resources of the state or the appropriate method of helping the poor. Indeed, he seems to have thought that the question didn't arise. This was because, in his view, reduced court fees were not really a state subsidy supported by taxpayers' money. He thought that in this respect they were different from legal aid, which the executive would be at liberty to regulate at its discretion. Now, I'm not saying that the result of this case was necessarily wrong, and in any event, it was subsequently given statutory force, but it cannot possibly be justified on the ground given. Since the cost of running the courts greatly exceeds the revenue derived from court fees, reducing court fees necessarily does involve a measure of public subsidy in just the same way as legal aid. The real question was not about the importance of keeping down court fees, it was about the relative importance of doing so, relative, that is, to other possible uses of the money or other possible ways of helping the poor. What the divisional court did was reduce the question before it to a binary question. Was it fundamental to the legal order that the poor should be able to afford court fees, yes or no? And by classifying the question in that narrow way, the court turned it into a question of law. If it had confronted the real issue, it might well have had to conclude that it wasn't a justiciable issue at all. Now, I cite this rather minor corner of English public law because it perfectly illustrates the problems associated with the judicial resolution of questions that have wider policy implications. This isn't a problem peculiar to English law. There has been a noticeable tendency in other common law jurisdictions to characterize as questions of law issues that do not really lend themselves to a legal solution. This tendency has been very marked in the United States for a long time. It was first noticed by the great French political scientist Alexis de Tocqueville as early as the 1830s. Scarcely any political question arises in the United States, de Tocqueville wrote, that is not resolved sooner or later into a judicial question. In Europe, much the most remarkable monument of this tendency to convert political questions into legal ones is the European Convention for the Protection of Human Rights and Fundamental Freedoms. This is such an important part of the current British and European legal scene that it is, I think, worth dwelling on it for a moment. The Convention is a treaty initially made between the non-communist countries of Europe in 1950, in the aftermath of the Second World War. It reflected the concern of European nations to ensure that the extremes of despotism and persecution characteristic of the German Third Reich were never repeated, as well as a growing fear of the new totalitarianism then coming into being in Soviet-dominated communist bloc. In all the 47 countries of the Council of Europe, the Convention now has the force of law. That is to say that it is not just an international treaty an international obligation of its signatory states. It is part of their domestic legal order. In the United Kingdom, effect has been given to it since 2000 by the Human Rights Act of 1998. Alone of the various international declarations of human rights, the European Convention provides for its enforcement by an international court, the European Court of Human Rights at Strasbourg, with the right to hear individual petitions and to make decisions which contracting states bind themselves to put into effect. In the United Kingdom, the courts have a statutory duty to give effect to the Convention so far as statute permits, and to have regard to the decisions of the Strasbourg Court. Now, the text of the Convention is wholly admirable. It secures rights which would almost universally be regarded as the foundation of any functioning civil society. A right to life and limb and liberty, access to justice administered by an independent judiciary, freedom of thought and expression, security of property, absence of arbitrary discrimination, and so on. And nothing that I have to say this evening is intended to belittle any of these truly fundamental rights. However, the European Court of Human Rights in Strasbourg stands for very much more than these. It has become the international flag-bearer of judge-made fundamental law, extending well beyond the text which it is charged with applying. It has over many years declared itself entitled to treat the Convention as what it calls a living instrument. The way that the Strasbourg Court expresses this is that it interprets the Convention in the light of evolving social conceptions common to the democracies of Europe, so as to keep it up to date. Now, put like that, it sounds innocuous, indeed desirable, but let us look behind the rhetoric and see what this means in practice. It means that the Strasbourg Court develops the Convention by way of extrapolation or analogy so as to reflect its own view about what rights are needed in a modern democracy. By doing this, it has transformed the Convention from the safeguard against despotism, which was intended by its draftsman, into a template for most aspects of the domestic legal order of its signatory states. This has involved the recognition of a large number of new rights which are not to be found in the language or even the spirit of the treaty. A good example is the steady expansion of the scope of Article 8. The text of Article 8 protects private and family life, the privacy of the home, and of personal correspondence. This perfectly straightforward provision was originally designed as a protection against the surveillance state by totalitarian governments. But in the hands of the Strasbourg Court, it has been extended to cover the legal status of illegitimate children, immigration, deportation, extradition, aspects of criminal sentencing, abortion, homosexuality, assisted suicide, child abduction, even the law of landlord and tenant, and a great deal else besides. None of these extensions are foreshadowed in the text of the Convention. They are all based on the sole authority of the judges of the Court of Strasbourg. The effect of this kind of judicial lawmaking is, in constitutional terms, very remarkable. It is to take many contentious issues which would previously have been regarded as questions for political debate, administrative discretion, or social convention, and to transform them into questions of law to be resolved exclusively by an international judicial tribunal. Now, there appear to me to be a number of problems about this particular way of making law. In the first place, it isn't consistent with the ordinary principles on which written law is elucidated by judges. A system of customary law, like the common law, may, indeed must, within broad limits, be updated and reformulated by the courts which made it in the first place. But very different considerations apply to a written instrument like the Convention, which records not just an agreement between states, but the limits of that agreement. The function of a court dealing with such an instrument is essentially interpretative, it is not creative. The Vienna Convention of 1969 on the law of treaties requires every treaty to be interpreted in accordance with the ordinary meaning to be given to its language, having regard to its object and purpose. The approach of the Strasbourg Court to human rights goes well beyond interpretation and well beyond the language, object, or purpose of the instrument. In practice, what it seeks to do is to keep the convention up to date by giving effect to the kind of convention that the court conceives, rightly or wrongly, that the parties might have agreed today and not the one that they actually did agree in 1950. This process necessarily involves the recognition by the court of rights which the signatories did not intend to grant, and some which we know from the negotiation documents that they positively intended not to grant. The second difficulty, it seems to me, is that the power to extrapolate or extend by analogy the scope of a written instrument so as to enlarge its subject matter is not consistent with the rule of law. It is a power which no national judge could claim to exercise in relation to a domestic statute, even in a common law system. It is subjective, it is unpredictable, and it is unclear. Beyond a very limited point, the reformulation of a written instrument so as to satisfy changed values since it was made is simply not a proper judicial function. Let me give you an example drawn from a recent English case. In Norris and the United States of America, a bold attempt was made by the divisional court to rewrite the elements of the common law offence of conspiracy to defraud so as to make it cover economic cartels. Economic cartels, although unlawful for many years, had hitherto not been regarded as criminal. Now, the divisional court's decision would have been perfectly acceptable by Strasbourg standards. It was a response to changing attitudes to economic manipulation. Cartels are a great deal less acceptable today than they were 100 years ago when the law in this area was originally made. But in the view of the House of Lords, which unanimously overturned the divisional court's decision, this was not an acceptable way for judges to change the law. Once a principle of law is established, Lord Bingham observed in his leading judgment, the requirement of certainty is not met by asserting that at some undefined later time a different view would have been taken. There are, of course, particular reasons for insisting on the requirement of certainty in criminal law, but albeit within broader limits, the same principle must surely apply to all law. It is far from clear why an approach to judge-made law, which would be constitutionally intolerable in the hands of our domestic court, should nevertheless be acceptable in those of an international tribunal with much less sensitivity to our domestic constitutional order or social conditions. The third problem is that the Strasbourg Court's approach to judicial lawmaking is fundamentally anti-democratic. This is a particular problem given the inherently political character of many of the issues which it decides. Most of the human rights recognized by the Convention are qualified by express exceptions for cases where the national law or the action complained of was necessary in a democratic society or some equivalent phrase. The case law of the Strasbourg Court provides a good deal of guidance about how these qualifications are to be applied. The court must decide whether the measure being challenged is necessary. Does it have a legitimate purpose? Does it conform to current practice among other signatories of the Convention? Does it pursue its purpose in a satisfactory way? What alternative and possibly less intrusive measures might have been sufficient for the purpose? Now, these are questions that have only to be stated for it to be obvious that they are questions of policy. Most people would regard them as inherently political questions, but their inclusion in the Convention to a considerable extent removes them from the arena of legitimate political debate by transforming them into questions of law for judges. Democratic legitimacy is, of course, a potential problem about all judge-made law. In a common law system, it has got to be accepted within reasonable limits. but it is a serious problem in the case of judicial decisions about supposedly fundamental rights. One needs to bear in mind that in a parliamentary democracy, the legislature can selectively enact into law whatever parts of the Convention or the case law of the European Court of Human Rights it likes. We don't need the Convention in order to introduce changes for which there is a democratic mandate. The Convention and its judicial apparatus of enforcement are only necessary in order to impose changes for which there is no democratic mandate. It is a constraint on the democratic process. Now, I think that most people would recognize, and certainly I recognize, that there must be some constraints on political democracy in the interests of protecting politically vulnerable minorities from oppression and entrenching a limited number of rights that the consensus of our societies recognizes as truly fundamental. Almost all written constitutions do this. But the moment that one moves beyond cases of real oppression and beyond the truly fundamental, one leaves the realm of consensus behind, and one enters that of legitimate political debate, where issues ought surely to be resolved politically. A particularly clear illustration has recently been provided by a highly charged issue about the right of convicted prisoners in the United Kingdom to vote in elections. The rule that they do not have that right has been part of the statute law of the United Kingdom since the inception of our democracy in the 19th century, and it has been regularly reenacted and reviewed since. It has a great deal of public support. It may or may not be a good rule, but it has nothing to do with the oppression of vulnerable minorities. Yet in two cases, the European Court of Human Rights has held that the automatic disenfranchisement of convicted prisoners is contrary to the Convention. In both cases, the Court's reasoning revealed its contempt for the democratic input into such matters. In the first, they brushed aside the argument based on democratic legitimacy on the grounds that Parliament cannot have devoted enough thought to the penal implications of what it was deciding. In the second, they disregarded it even more summarily on the ground that the issue was a matter of law for the court and implicitly, therefore, not a matter for democratic determination at all. But of course, to say that it is a question of law is simply to point out the problem. The Strasbourg Court directed the United Kingdom to bring forward legislative proposals intended to amend the relevant statute. The government has brought forward legislative proposals, but the United Kingdom, as is its privilege in a democracy, has declined to approve them. The resultant collision between an irresistible force and an immovable object was considered a month ago by the Supreme Court in the Crown on the application of Chester against the Secretary of State for Justice, in which we held that as a court we were bound to follow the law repeatedly declared by the Strasbourg Court, although we declined to grant a remedy as a matter of discretion. The case law of the European Court of Human Rights, which is largely based on the Court's view of what is appropriate to a democratic society, is an interesting example of the abuse of political vocabulary. Properly speaking, democracy is a constitutional mechanism for arriving at decisions for which there is a popular mandate. The Convention and the Strasbourg Court use the word in a completely different sense, as a generalized hurrah word to describe a set of approved legal values which may or may not correspond to those that a democracy would in fact choose for itself. The imposition of these values by law, for which there is no popular mandate, is democratic only in the sense that the old Soviet-style Democratic Republic of East Germany was democratic. In his famous essay, Politics and the English Language, written in 1946, George Orwell observed that if thought corrupts language, language can also corrupt thought. Democracy was one of the catalogue of words that he singled out as having become largely meaningless as a result of its abuse by people intent on imposing their own values. Personally, speaking as a citizen rather than a judge, I happen to think that most of the values which underlie judicial decisions on human rights, both at Strasbourg and in the domestic courts of the United Kingdom, are wholly admirable. But it does not follow that as a citizen I am at liberty to impose them on a majority of my fellow citizens who may disagree without any democratic process. The answer which is normally put forward to defend the democratic credentials of this kind of judge-made law is that Parliament has implicitly authorized it by not reversing the decisions which it didn't like, or in the case of decisions of the Strasbourg Court, by passing the Human Rights Act of 1998. This is, however, rather an artificial argument. The treatment of the Convention by the European Court of Human Rights as a living instrument allows that court to make new law in respects which are not foreshadowed by the language of the Convention, and which therefore Parliament could not have anticipated when it passed the Human Rights Act. It is incapable of being reversed by legislation, short of withdrawing from the Convention altogether. In reality, therefore, the Human Rights Act involves the transfer of part of an essentially legislative power to another body. The suggestion that this is democratic simply confuses popular sovereignty with democracy. Of course, a sovereign parliament can transfer part of its legislative power to other bodies which are not answerable, even indirectly, to the people of the United Kingdom. But it would be ridiculous to deny that that undermines the democratic process simply because Parliament has done it. A democratic Parliament may abolish elections or exclude opposition or appoint a dictator. It may even have a popular support in doing these things, as the last National Assembly of the French Third Republic probably did when it conferred absolute powers on Marshal Pétain in 1940. But that would not be to make it democratic. Now, I have spoken of these matters in a British context because it's where my own experience lies. But the frame of mind underlying the case law of the European Court of Human Rights is symptomatic of a much wider phenomenon, namely the resort to fundamental rights declared by judges as a prime instrument of social control and entitlement. The main casualty of that approach is the political process, which is no longer decisive over a wide spectrum of social policy. In many countries, including the United Kingdom, there is widespread disdain for the political process and some articulate support for an approach to lawmaking that takes the politics out of it. This reflects the contempt felt by many intelligent commentators for what they regard as the illogicality, intellectual dishonesty, or irrational prejudices characteristic of party politics. The American philosophers John Rawls and Ronald Dworkin have perhaps been the most articulate spokesmen in modern times of this point of view. I think that their attitude, which is shared by some judges, misunderstands some fundamental features of the political process. Democracy requires a minimum degree of social cohesion and tolerance of internal differences in order to function properly. But provided that these conditions exist, I would like to suggest to you that politics is quite simply a better way of resolving questions of social policy than judge-made law. The public law questions which come before the courts are very commonly presented as issues between the state and the individual, but most of them are in reality issues between different groups of citizens. This applies particularly to major social or moral issues on which strong and divergent positions are taken. The essential function of politics in a democracy is to reconcile inconsistent interests and opinions by producing a result which it may be that very few people would have chosen as their preferred option, but which the majority can live with. Political parties are rarely monolithic. Although sharing a common outlook, they are usually unruly coalitions between shifting factions, united only by a common desire to win elections. They therefore mutate in response to public sentiment in the interests of winning or retaining power. In this way, they are a highly effective means of mediating between those in power and the public from which they derive their legitimacy. They are instruments of compromise between a sufficiently wide range of opinions to enable a programme to be laid before the electorate with some prospect of being accepted. It is true that the political process is often characterised by opacity, fudge, or irrationality, and who is going to defend those? Well, at the risk of sounding paradoxical, I am. They are tools of compromise. They enable divergent views and interests to be accommodated. The result is probably intellectually impure, but it is very much in the public interest. Unfortunately, few people recognise this. They expect their politicians to be not just useful, but attractive. They demand principle, transparency, consistency. And when they don't get these things from politics, they are inclined to turn to courts of law instead. The attraction of judge-made law is that it appears to have many of the virtues which the political process lacks. It is transparent, it is public. Above all, it is animated by a combination of abstract reasoning and moral value judgment, which at first sight appears to embody a higher model of decision-making. There is, however, a price to be paid for all this. The judicial resolution of major policy issues that undermines our ability to live together in harmony by depriving us of a method of mediating compromises among ourselves. Politics is a method of mediating compromises in which we can all participate, albeit indirectly, and which we are therefore more likely to recognise as legitimate. In the 1960s, the United Kingdom Parliament enacted a number of measures designed to liberalise long-standing features of our law. Two notable monuments were the statutes decriminalising homosexuality and the authorisation in certain circumstances of abortion. These measures were very controversial and were strongly opposed by significant sections of the public. In both cases, however, the parliamentary debates squarely addressed the moral issues and represented the whole spectrum of contemporary opinion. As a result, by and large, the results of these enactments have been accepted, and the principles underlying them have become largely uncontroversial. This is, as it seems to me, the paradigm case of how the political process ought to work. It also suggests that it is perfectly capable of accommodating major moral issues, which would today be characterized as engaging human rights. I venture to suggest that if similar reforms had been imposed judicially, they would not have been so readily accepted. The continuing controversy in the United States about the decision of the US Supreme Court in Roe and Wade to recognize judicially the almost unrestricted constitutional right of a woman to an abortion certainly suggests that that is so. I have already mentioned Professor Ronald Dworkin, whose death last year deprived us of one of the most formidable defenders of rights-based law defined by judges. He defended it against those who would leave this to the legislature by suggesting that judges were more likely to get the answer right. I cannot imagine, he wrote, what arguments might be thought to show that legislative decisions about rights are inherently more likely to be correct than judicial decisions. The problem about this is that it assumes a definition of correctness which is difficult to justify in a political community. How do we decide what is the correct answer to a question about which people strongly disagree, without resorting to the political process to mediate that disagreement? I think that the outcome has got to be more than correct. It's got to be acceptable. Rights are claims against a claimant's own community. They depend, in a democracy, on a measure of recognition by that community. To be effective, they need a large measure of public acceptance through an active civil society. And that is something that no purely judicial decision-making process can ever achieve. But I would go further than this. Unlike Professor Dworkin, I can imagine why legislative decisions about rights are more likely to be correct than judicial ones. The reason, as it seems to me, is that rights can never be wholly unqualified. Their existence and extent is inevitably constrained by the rights of others, as well as by some legitimate collective interests. So in deciding where the balance lies between individual rights and collective interests, the relevant considerations will be much wider than anything that a court can comprehend simply on the basis of argument between the parties before it. Lon Fuller famously described these as polycentric problems. What he meant by that was that any decision about them was likely to have multiple consequences, each with its own complex repercussions for many other people not represented before the court. We may visualize this kind of situation by thinking of a spider's web, he wrote. A pull on one strand will distribute tensions after a complicated pattern through the whole web. In such a case, he suggested, it was impossible to afford every legitimate interest a hearing. One of three consequences followed, and quite possibly all three at once. First, the judge may produce a result which, because of its unexpected repercussions, is unworkable or ineffective or obstructive of other legitimate activities. Secondly, the judge may end up by acting unjudicially. He may consult third parties or guess about facts about which he has no sufficient knowledge. Thirdly, he may reformulate the issue so as to make it a one-dimensional question of law in which the only relevant interests appear to be those of the parties before the court and all others ignored, which is what the divisional court did in Mr. Whiteham's case. Decisions made in this way are necessarily made on an excessively simplified and highly inefficient basis. They have a large probability of being bad decisions. Now, I would be the first to acknowledge that some degree of judicial lawmaking is unavoidable in an uncodified common law system especially. Even in a case where the limits have been exceeded, I'm not going to suggest to you that the fabric of society will break down because judges make law for which there is no democratic mandate. The process by which democracies decline is a more subtle one than that. They are not usually destroyed by a sudden external shock or by unpopular decisions. The process is usually much more mundane and insidious. What actually happens is that they are slowly drained of what it is that makes them democratic, by a gradual process of internal decay and mounting indifference, until quite suddenly one notices that they have become something else, like the republican constitutions of Athens or Rome, or the Italian city-states of the Renaissance. I believe that this is an outcome which is worth fighting against.
Distinguished guests, ladies and gentlemen, I would like to thank the Right Honourable Lord Jonathan Sumption for such an enlightening lecture. We are grateful to him for sharing with us his thought and what should concern us today in the development of the law. Thank you, sir, once again. On behalf of the University of Malaya, I would like to thank all our distinguished guests and those present for taking the time to attend this prestigious lecture. My thanks also go to the Sultan Azlan Shah Foundation and Malaysian Airlines for their generous contribution to this lecture. I would like to express my appreciation to Yang Berbahagia Tan Sri Dr. Visu Sinadurai, also to Protocol and Ceremony Division of Perak Darul Rizwan, to the Deans of the Faculty of Law, and all staff who contributed to the success of this public lecture. Ampun tuanku, patut sekali lagi menjunjung kasih di atas perkenan duli-duli tuanku berangkat dan menyerikan siri kuliah undang-undang Sultan Azlan Shah ini. Sekian, terima kasih. Wabillahi taufiq wal hidayah. Wassalamualaikum warahmatullahi taala wabarakatuh.
Your Royal Highnesses, distinguished guests, ladies and gentlemen, with the stimulating lecture delivered by the Right Honourable Lord Sumption, we come to the successful conclusion of the 27th Sultan Azlan Shah Law Lecture. Your Royal Highnesses, Lord Sumption and Lady Sumption, Your Highnesses, distinguished guests, my lords, your excellencies, ladies and gentlemen, may I humbly invite you to the reception. Ampun Tuan.